the probation offer that's been made?
That is correct, Your Honor.
This was at Hope House?
Yes, sir, it was.
Ellsbury, raise your right hand, please. Do you swear or affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Yes, sir.
Please state your full name and date of birth.
Kayla Rachel Salisbury, born August 14th of 90.
I'm looking at the guidelines. There's no prior record.
Not that we were aware of, Your Honor.
Okay. And is that also part of the basis for the probation offer?
Yes, Your Honor, it is.
All right, Ms. Salisbury, you're here in 24 CF 2925. You're charged with cruelty toward a child without great injury, which is a third-degree felony and punished by up to 5 years in state prison. Do you understand that?
Yes, sir.
I've been handed a plea and sentencing agreement between you and the state that calls for 36 months of probation, standard terms and conditions, a substance abuse evaluation, any recommended treatment, successfully completed anger management program, also no alcohol, no marijuana, including medicinal marijuana, $666 in court costs, and then early termination at 24 months if you complete all of those things. Is that your understanding?
Yes, sir.
Is that the state's agreement?
Yes, Your Honor, and we want to be very clear that completing it includes no violations. So no positive drug tests, anything of that nature, even a technical.
So, Ms. Salisbury, do you understand that any violation, including a technical violation for not reporting on time or being outside of an area you're supposed to be, could lead to you not getting early termination?
I understand, yes.
Okay. All right, have you gone over this plea and sentencing agreement with your lawyer?
I have.
Did you understand it?
Yes, sir.
Did you sign it?
Yes.
Are you satisfied with your lawyer's advice and representation?
Yes, sir.
Are you currently under the influence of any alcohol, drugs, or controlled substances?
No, sir.
Are you currently suffering from any mental health issues?
No, sir.
Has anyone forced, pressured, or threatened you in any way to enter this plea?
No, sir.
Has anyone promised you anything in return for your plea?
No, sir.
Is no contact with the victim supposed to be a part of this plea offer?
Yes, Your Honor, it should have been.
All right, Ms. Salisbury, do you understand that if you do enter a no contest plea, there won't be a trial of any kind?
Yes, sir.
And do you understand that you're giving up all your trial rights, which are on page 1 of the agreement you signed?
Yes.
And do you understand that you're waiving all potential defenses that you may have?
Yes.
And what is your plea?
No contest.
Accept your no contest plea is freely, voluntarily, knowingly given. Withhold adjudication, sentence you to 36 months probation, standard terms and conditions, substance abuse evaluation, any recommended treatment, anger management, no alcohol, no marijuana, including medicinal marijuana, cost of $666, early term at 24 months if all terms are complete and there are no violations. Also, no contact directly or indirectly with the victim in the case.
Yes, sir.
All right. Need you to speak with probation, and you have 30 days to appeal the judgment and sentence of the court.
Yes, sir.
Your Honor, is that a shall terminate, or do you want us to come back to court if she complies or completes the 20?
What was the state's agreement on that?
Your Honor, our request is that she come back to the court, that it's not automatic.
Okay.
May.
Yes,
So
please.
May. All right. So it'll be May terminate. All right. Thank you, Ms. Salisbury.
Thank you.
All right. What else do you have, Mr. Gilbert?
Next case, Your Honor, Shannon Smith in 24 CF 2896. He is present and approaching. May I approach?
No, not you, sir. Just him.
Agreement with the state, he's agreed to enter into a PTI.
Plea to PTI?
No, Your Honor, just PTI.
All right. So Mr. Smith, do you understand that in 24 CF 2896, you've signed an agreement for pretrial intervention on the charge of insurance fraud? Did you go over this document with your lawyer?
Yes, Your Honor.
All right, did you understand it?
Yes, Your Honor.
Is that your signature on here?
Yes, Your Honor.
Okay. All right, so it's not going to be a plea, so basically you're just going to be taken off the docket. I'm going to have Mr. Gilbert give this back to probation because they need the original, and then you won't have a further court date unless there's a violation or you fail to successfully complete your pretrial intervention. Do you understand that, Mr. Smith?
Yes, Your Honor.
All right. Mr. Gilbert, can you give that back to probation? All right, meet with probation when they're ready. It's a PTI without a plea.
And that's all I have this morning, Your
All right,
Honor.
thank you, Mr. Gilbert.
Thank you.
Mr. Cobb?
Judge, this plane was diverted all week, but it's finally here, ready to land. This plane was diverted all week, but it's finally here. We took care of the misdemeanor with Judge Ward, I believe, on Wednesday, so. No, we gotta do it, okay, we gotta do it. So this is State versus Eddie Hudson in 25 CF 133 and 24 CF 741. That's the violation of probation case. He's gonna enter a plea of no contest to the new charge and admit the violation of probation. 1129, credit for time served. Can I approach? No sentences are run current with UC. 1129, he received on Wednesday. No contact with the victim and the felony battery on a jail detainee case. And there's some cost of investigation to Niceville Police Department.
Looks like it doesn't score, so this is a guideline sentence, correct?
Yes, sir.
All right, Mr. Hudson, can you raise your right hand? Do you swear or affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth? Okay, can you state your full name and date of birth, please?
Eddie James Hudson, 12-5-85.
You can put your hand down, Mr. Hudson, thank you. All right, Mr. Hudson, as your attorney announced, you're here in 25 CF 133 with a new case of battery on a jail detainee, which is a third-degree felony, punishment up to 5 years in state prison. Also in 24 CF 741, it's a violation of probation for 1 third-degree felony and 1 misdemeanor, so that's up to 5 years, and then 1129 possible on that. I've been handed a plea and sentencing agreement that would call for you to be adjudicated guilty on all counts in both cases. Sentenced to serve 11 months, 29 days in the county jail with credit for all time served. Your sentence would run concurrent as to both cases and concurrent with the sentence in 25 MM 111, which you pled to on Wednesday, and no contact with the victim in 25 CF 133 and $94.44 to Niceville Police Department.
Yes, sir.
Is that the agreement that you've made with the state?
Yes, yes.
All right. Did you go over this form with Mr. Cobb, your attorney?
Yes.
And did you understand the agreement?
Everything's concurrent, 1129, credit for time served, and then I'll be a felon now, I guess, right? I'm like,
You would be a convicted felon
Right.
because of the adjudication.
right.
You understand all that?
Yeah,
All right. Did you sign this agreement?
yes, sir.
Are you satisfied with your attorney's advice
Yeah,
and representation?
yes, sir.
What would the court cost me on the new one? Okay. All right. Mr. Hudson, are you currently under the influence of any alcohol, drugs, or controlled substances?
No, sir.
Are you currently suffering from any mental health issues?
No, sir.
Has anyone forced, pressured, or threatened you in any way to enter this
No,
plea?
of course not.
Say again.
No, of course not. No, sir.
Well, I've got to ask the same questions to everybody. Has anyone promised you anything in return for your agreement?
No, sir.
All right, do you understand that if you enter a no contest plea to your new charge, there won't be a trial of any kind? And do you understand that you're waiving all of your trial rights, which are listed on page 2 of the agreement that you signed?
Yes, sir.
All right, and on the violation of probation, if you admit that you violated your probation, do you understand there won't be an evidentiary hearing where the state would have to prove that you violated your probation?
Yes.
Okay, you understand there won't be a trial or a
Right.
hearing to determine if you did this or not? Because you'd be admitting to that today.
All right, yes, sir.
Okay. All right, do you understand that you're waiving any potential defenses that you may have? Okay. So in the 24 CF 741, the violation of probation, are you admitting or denying that you violated your probation?
I admit it, I violated, yeah.
Okay.
I violated.
And in 25 CF 133, what is your plea to the battery on a jail detainee?
No contest.
All right, I'll accept your no contest plea in 25 CF 133 and your admission to probation, or violation of probation in 24 CF 741. Adjudicate you guilty on all counts in both cases, 11 months, 29 days in the county jail on all 3 counts, with credit for all time served. Sentences to run concurrent as to both cases and also concurrent with sentence in 25 MM 111. No contact with the victim in case 25 CF 111, or 133, I'm sorry. And also $94.44 cost of investigation to the Niceville Police Department. In 25 CF 133, you'll have $867 in court costs. And then on the VOP, it's a $100 VOP fee. Do you understand that? Okay. Anything that I've missed? Hearing nothing. Yes, outstanding money to collections.
Good luck, man. Stay out of trouble. Yes, sir, I'm,
All right. Thank, and when he says we can go, we'll go. See you later. All right, Judge, that's...
Sorry, Mr. Hudson, you have to be fingerprinted. You have 30 days to appeal the judgment and sentence of your, in this case.
Thanks, Judge.
All right. Anything
That's all I
else?
have.
You didn't have anything else? I know there was something about yesterday. I guess that was taken care of.
Yes, that was
Okay.
taken care of. Yes, sir.
I offered that you could handle it today if there was something else that was needed.
All right. Thank you, Judge.
All right, thank you, Mr. Cobb. All right. Anybody else ready?
Judge, I'm ready
Okay.
whenever, but I thought I heard Ms. Leone say that she had a case, a victim that needs to get out and get to work, that she was
Okay.
going to call up.
You want to call that one, Ms. Leone?
Yes, Mr. Nicolas Espinosa.
Espinosa?
Did I sign it? I didn't sign it. Did you?
Judge Charles Russell, Public Defender's Office. I'm covering for Mr. Maddox today. This is Nicholas Espinosa. Case number for the record is 24 CF 2353. On Mr. Espinosa's case, the state and the defense have worked out a plea to a PTI agreement, and I have both if you want me to approach.
Ms. Leone said that the victim is present,
Yes, Your Honor, Mrs. Espinosa is here.
and have you talked to the victim about this resolution?
Yes, Your
Was there
Honor, I
any
have.
objection to it?
No, there was.
Did she want to be heard while she's here?
No, Your Honor.
Okay. All right. Mr. Espinosa, can you raise your right hand? Do you swear or affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Yes, sir.
Okay. Can you state your full name and date of birth, please?
Nicholas Mateo Espinosa, 52305.
Okay, you can put your hand down, Mr. Espinosa. You're here currently charged with 2 counts of aggravated assault, and which are third-degree felonies, as well as a count of misdemeanor battery. Do you understand those charges?
Yes, sir.
All right, and I've been given a plea and sentencing agreement with the state that calls for you to enter a plea to each of those charges but then you'll do a pretrial intervention agreement, and if you successfully complete that, the state would dismiss the case. But if you're not successful in that, if you have to come back to court because you failed the terms of those of that agreement, you would go straight to sentencing. Do you understand that?
Yes, sir.
All right. So even though it potentially will be dismissed, you'd be giving up your right to a trial. Do you understand that?
Yes, Your Honor.
All right. Let's go through all this. Did you go over the plea and sentencing agreement and the pretrial intervention agreement with your lawyer?
Yes, Your Honor.
Did you understand it all?
Yes, Your Honor.
Did you sign them?
Yes, Your Honor.
Are you satisfied with your attorney's advice and representation?
Yes, sir.
All right. Are you currently under the influence of any alcohol, drugs, or controlled substances?
No, Your Honor.
Are you currently suffering from any mental health issues?
No, Your Honor.
All right. Has anyone forced, pressured, or threatened you in any way to enter this plea?
No, Your Honor.
Has anyone promised you anything in return for your plea?
No, Your Honor.
All right. And did you go over all of these terms that you have to do as part of your PTI?
Yes, Your Honor.
Okay, so you're to obtain a valid driver's license, maintain employment, or show proof of at least 5 applications submitted per week. Mr. Espinosa?
Yes, Your Honor.
Okay. Have no contact with the victim, Stephanie Espinosa, and a minor child. Do we know?
Max.
Max.
Yes, Your Honor.
Okay. Obtain your GED and take all medications as prescribed are the specific terms of the PTI. Do you
Yes, Your
understand? Okay. And do you understand that by entering a plea and doing the PTI that you're giving up your right to a trial on those 3 charges?
I do, Your Honor.
And do you understand that you're giving up your right, all the rights that are associated with trial, which are on page 2 of the plea and sentencing agreement that you've signed?
Yes, Your Honor.
Okay. Do you understand you're waiving all potential defenses that you may have?
Yes, Your Honor.
Do you understand that if you're not a U.S. citizen, you could be deported because of this?
Yes, Your Honor.
And what is your plea to the pretrial intervention agreement for the aggravated assault ×2 and battery?
No contest.
Oh, all right. I'll accept your no contest. Plea is freely, voluntarily, knowingly given. Require you to complete the terms of your pretrial intervention agreement. Upon successful completion, again, the state will dismiss the case. If not completed, you'll proceed straight to sentencing.
Yes, Your Honor.
Okay. And I've got the agreement here for probation. Thank you, Mr. Russell. Anything else, Mr. Berry? Okay. Anything else for Mr. Espinosa?
No, sir. I think that's it, Judge.
You've got 30 days to appeal, but obviously it's a pretrial intervention. I'm not sure what there would be there.
Thank you.
But go ahead.
Judge, I have another plea
Go
with a
ahead.
PTI. Mr. Deacle, Benjamin Deacle. Judge, this is Benjamin Deacle, present and approaching. Case number is 24 CF 2338.
Who's this going to be under, Mr. Russell?
Oh, it's going to be under Mr. Maddox. Sorry,
Okay,
Judge.
no, that's fine. I just want to be able to find it. There it is.
And we have a signed plea agreement, and it's to complete a PTI again, Judge. May I approach?
Yes. So it's PTI for him to get a valid driver's license and then it terminates?
I guess that's the
That's the
agreement, Your
terms,
Honor.
Judge. She's covering for Mr. Sheik, Judge.
Okay,
Yes.
I understand. All right, Mr. Deacle, can you raise your right hand? Do you swear or affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
I do, sir.
All right. Mr. Deacle, you're here in 24 CF 2338, charged with 1 count of violation of a driver's license restriction by a habitual traffic offender. Do you understand that charge?
Yes, sir.
All right, which is a 3rd-degree felony punishable up to 5 years in state prison. I've been handed a plea and sentencing agreement that calls for you to do a pretrial intervention. Is that your understanding?
Yes, sir.
Is that what you want to do here today?
Yes, sir.
I'm sorry, can you state your full name and date of birth? I think I skipped over that.
Benjamin Leonard Deacle, 9/27/71.
Okay. And did you go over this paperwork, the agreements with your lawyer?
Yes, sir, I did.
Did you understand and sign those paperwork, those
Yes, sir, I did.
documents?
Yes, sir.
And are you satisfied with the work of your attorney?
Yes, sir.
And are you currently under the influence of any alcohol, drugs, or controlled substances?
No, sir.
Are you currently suffering from any mental health issues?
No, sir.
Has anyone forced, pressured, or threatened you in any way to enter this plea?
No, sir.
Has anyone promised you anything in return for your plea?
No, sir.
All right, do you understand that if you enter this plea, even to pretrial intervention, that there won't be a trial of any kind?
Yes, sir.
And you understand that if you don't complete your pretrial intervention agreement, that you'll go straight to sentencing,
Yes, sir.
where you can receive up to that 5 years in state prison?
Sure.
You understand you give up all your trial rights, which are listed on page 2 of the plea and sentencing agreement that you signed?
Yes, sir.
Are you waiving all potential defenses that you may have?
Yes, sir.
All right. And do you understand that if you're not a U.S. citizen, this could lead to your deportation?
Yes, sir.
All right. And what is your plea to the violation of driver's license restriction by a habitual traffic offender?
No contest, Your Honor.
All right. I'll accept your no contest plea as freely, voluntarily, knowingly given. Place you on the pretrial intervention program that you've signed. Upon successful completion, the state will dismiss your case. And the one term of it basically is to pay some costs, I believe, as well as obtain a valid driver's license and early termination upon completion. So the sooner you get a driver's license, the sooner this will be over.
Yes, sir.
And then you understand again that we'll go straight to sentencing if you come back on a violation.
Yes, sir.
Okay. We've got 30 days to appeal, Mr. Deacle. I'm going to give this back to you, Mr. Russell, so you can give it to Mr. Berry. Make sure you talk to probation before you leave.
Yes, sir. Thank you, Your Honor.
Thank you, Your Honor.
Anything else, Mr. Russell?
I've got others, but they're inmates, Judge, and if other people want to go.
Oh, Mr. Riasti, is he up? Okay. Mr. Riasti?
Morning, Your Honor.
Joseph Riassi for Christian Alexander Douglas, who's present before the court, Your Honor. This case was set for a status call with regard to cell phone data, and I've been in communication with Ms. Leone concerning the issues that we spoke at the last hearing, and I have retained an expert, and the expert believes that he could get everything done. He was expecting the cell phones to be shipped to him, and I didn't really understand that. And Ms. Leone has said that they need to remain in the sheriff's office. And after speaking with him, he said, yes, that's what generally is done, that he comes up here.
Where's he coming from?
He's coming from the Orlando area. But
You're appointed to this case, right?
I am, and
So
he's a JAC contracted attorney, and I have the motion already prepared. I was going to file it before this, but there's also the issue of Ms. Leone wanting reciprocal discovery with regard to the data that's on the phone, and our position is that that we don't have to provide all of the data, and also we had requested that the state provide us the data that's on the other two telephones. And the state believes that that's protected. So I think maybe the best thing to do is
it's protected.
That it's that both of the individuals who own the cell phones have an expectation of privacy of the data that's on the telephone, and that just because the state has them in their possession doesn't mean that they have to provide the cell phone data that's on there. And then I asked them, well, what was the purpose of having the cell phones for this long? She said that the state can hold the cell phones for any reason that they believe that there's evidentiary value, and I agree with that position. But
is there potentially exculpatory
there could
evidence
be
on those phones?
There is.
We don't know that, Your Honor. That's the whole idea.
But you're holding them and preventing anyone else from seeing them.
Yeah, first, nobody has asked for it. Second, there is
Just
no
did.
probable cause at this time to get into the witness phones and the victim phones.
So what I propose is
Hold on, Ms. Rhea. So law enforcement took the phone consensually or unconsensually from the victim? That's who it is, right? It's the victim.
One is the victim, one is a witness.
Okay. So why were they taken into custody?
They always take them into custody. For example, the independent witness's phone can be released to her, but she never requested to get it back. So LCSO keeps it. That has no bearing really to the crime because she was arrested with the defendant about a year after the incident.
Okay.
and for the record, we don't believe that there's any significant evidentiary value to that individual's phone, but the victim's phone is potentially exculpatory evidence on it. In that there may be text messages for another individual. My client denies that he committed this crime. He denies that he was in the area and had any opportunity to do that. And if the victim was, for instance, text messaging another individual, say the girlfriend, the mutual girlfriend, that is potentially the reason for all of this occurring, moments before the alleged shooting occurred, then that would be, in my opinion, exculpatory evidence, and we'd like to have access to that. So the court at the previous hearing suggested that I file a motion to compel, and I held off on filing a motion to compel to this hearing because I wanted to talk to Ms. Leone about her position, and I didn't want to file any kind of aggressive pleadings.
I don't think filing a motion to compel in a case that's 2.5 years old, so you can see potential evidence that's in the state's possession is aggressive.
Well,
If anything, I would say it's the opposite of aggressive.
I felt that I would just wait to this hearing to find out what her position was in the court's direction.
I understand that part of it, Mr. Riossi. It's just, again, this case is, I think, 2.5 years old from from January of 2023, so just about 2.5 years old.
The expert that I have says that he can, not only can he do the download of the phone and go through all of that data, but he could also most likely provide any GPS information with just the data that's on the phone without having to. And we're going to pursue subpoenaing Metro PCS, but he believes that he can provide GPS data without that potentially, based upon what he believes the content of the phone would have. So with regard to his phones, I think we can provide what my client wishes and what would be necessary to prepare for trial between now and the next pretrial. And with regard to the victim's phone, that could also be done, but obviously it would be over the state's objection, and I think maybe a hearing needs to be set with regard to.
A motion needs to be filed and a hearing needs to be set. All right, what's the state's position? Let's start off with the defendant's phones.
Yes, Your Honor. I have had a conversation with the lead investigator, Kelly Henderson, and I've asked her to prepare a search warrant for the defendant's phones, also based on the statements that he made under oath in court on docket day, claiming that there is...
Search warrant to search something y'all have had in your possession for 2.5 years.
Yes, Your Honor.
It addresses the staleness of the information that's going into it.
The evidence has been preserved.
Okay.
So it's still contained in the phone. If it was before, it should be still now. We're applying for a search warrant, so we will go ahead and, upon approval of the search warrant, within 10 days, we will search the phone. We will do the phone download. And I will download the victim's phone as well.
So you're going to get a search warrant for the victim's phone as well?
No, I can get consent from the victim.
I think we're set for June 24th then for our next pretrial conference. Obviously, if any motions are going to be filed, they should be filed quickly and set for hearing quickly. I don't like the idea of these cases being this old with seemingly early discovery issues still in place.
I would just suggest, Your Honor, if I may, that Mr. Riossi goes ahead planning for his expert, to come here in the event that for whatever reason the state, through the Sheriff's Department, is not able to obtain the download.
Okay.
Thank you.
All right. Anything else, Mr. Riossi?
No, Your Honor.
Anything from you, Mr. Douglas? You understand what's going on here?
I explained it to him, Your Honor, and I'll explain it thoroughly at the jail.
I would like this case to get to a resolution. If that's going to be a trial, let's get it set.
Yes, Your Honor. That's all I have
All
before
right,
you.
thank you, Mr. Douglas.
Yeah, I'll be filing a motion to compel.
Mr. Henderson. All right, Mr. Henderson.
Morning, Judge.
Morning.
Tony Henderson for Anthony Miles.
All right, and this is 19 CF 3289. What are we doing, Mr. Miles, today?
Judge, we're going to withdraw any previous not guilty pleas and a plea of no contest to an agreement.
I don't have the score sheet, I'm sorry. I'll have to get the score sheet to the court, Your Honor.
Is it going to be different from his other pleas that what was that, Monday or last week?
The same charges will be, they'll just be in different positions. For instance, the human trafficking charge will be a prior. It won't be a concurrent. So that's why I have to rewrite it.
Let me kind of see the.
May I approach?
Yes, sir. Thank you, sir. Mr. Miles, raise your right hand. Do you swear or affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Yes.
All right, Mr. Miles, you're here in 2019 CF 3289, charged with harassing a witness, victim, or informant, which is a first-degree felony punished by up to 30 years in state prison. I've been handed a plea and sentencing agreement between you and the state that calls for you to be adjudicated guilty upon a plea of no contest, sentenced to 5 years in the Department of Corrections, credit for time served, and this will be concurrent with the other two pleas you just took in the past week, which is 17 CF 3441 and 20 CF 1370. Is that what you want to do here today?
Yes.
Is that the state's agreement?
It is the state's agreement, Your Honor.
Okay. Anything else the state wants to put on the record as far as the plea?
No, sir.
All right. Is this a guideline sentence?
I believe it is, Your Honor. I'm trying to get that worked out right now for you, but it is a DOC incarcerative.
Well, I just want to make sure if it's a downward departure, we're talking about that. So if you can get me I don't remember what the number was from the other cases, but I think he got 8.5 years on the other case.
Did, Your Honor. The other ones become priors. That's why I need to
I know, if it's a,
check that. I'm trying to get. It's gonna take- Your Honor, it is going to take me a moment if the court wishes to move on to another case, or if just wants to address the score sheet later.
well, this is. Before I accept his plea, I'd like to know what the score sheet is, just so
Yes,
I know
sir.
if it's a downward departure or not, because I'm looking at the score sheet from the other case. Obviously, again, like you said, Ms. Basso, the numbers will change because that's a prior as opposed to the primary, but he scored 70.65 months before. I'd just like to know what the number is so that I can determine if there needs to be a reason for a downward departure or not. Why don't we recall Mr. Miles, and we'll address it once we've got that number.
Yes, Your Honor.
All right, thank you, Mr. Henderson. What do we have lined up? Rivers. That's Rivers.
Your Honor, this is Vernon Webb before the court on 22 CF 2054 and 22 CF 2749. He needs a moment to sign the plea agreement.
This was an add-on, right?
Yes, Your Honor. All right, sign it right there. Just put the date. I may approach, Your Honor. And Your Honor, he is on supervision until February of next year. This will be an extension of the supervision beyond community control for an additional 6 months.
So he's already on probation.
Yes, Your Honor.
And how long has he been incarcerated on these cases?
When did you get arrested?
You mean right now? Oh, it's been 4 months.
4
4
months?
months, but, yeah.
All right, Mr. Webb, can you raise your right hand? Do you swear or affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Yes, sir.
All right, can you state your full name and date of birth, please?
Vernon Brent Webb, 12/04/1953.
Mr. Webb, you're here in 22 CF 2749 and 22 CF 2054, but both of which have, there are 2 counts on each or just one?
2 counts on each, Your Honor.
I'm showing one.
Or just one?
I think it's just one. At least on the 2749, I'll look at the other one. Yeah, I'm showing just one. All right, so in each of those cases, you're here for a violation of probation, Mr. Webb, do you understand that?
Yes, sir.
Okay, and I've been given a plea and sentencing agreement on that violation of probation that would call for you to admit that you violated your probation in the ways that the state has alleged. You'd have to, you'd be adjudicated guilty, you'd be reinstated to community control, and that would be extended 6 months. You'll continue to have an electronic monitor at $1 per day, reinstate all your previous terms and conditions of probation, waive cost of supervision due to the fact that you're indigent, $100 court cost, $100 cost of prosecution, $50 application fee.
Yes, sir.
Is that your agreement?
Yes, sir.
Is that the state's agreement?
It is the state's agreement, Your Honor.
All right, thank you. All right, Mr. Webb, did you go over this plea and sentencing agreement with Ms. Rivers, your attorney?
Yes, sir.
Did you understand it?
Yes, sir.
Did you sign it?
Yes, sir.
Are you satisfied with Ms. Rivers' advice and representation in this case?
Absolutely.
Okay. And are you currently under the influence of any alcohol, drugs, or controlled substances?
No, sir.
Are you currently suffering from any mental health issues?
No, sir.
Has anyone forced, pressured, or threatened you in any way to enter this
No,
plea?
sir.
Has anyone promised you anything in return for your plea?
No, sir.
You understand by entering an admission to your violation of probation, there won't be an evidentiary hearing where the state would have to prove that you violated your probation?
Yes, sir.
And you understand that you're waiving any potential defenses that you have to the violation of probation?
Yes, sir.
And looks like you were adjudicated guilty on the underlying offense, so you understand that you'll remain adjudicated on that offense?
Yes, sir.
Okay. And do you understand that this plea could lead to your deportation if you're not a U.S. citizen?
Yes, sir.
All right. Any questions?
No, sir.
All right. And what is your... Oh,
Well, no, sir. No, sir.
okay. And what is your plea to the violation of probation? Are you admitting or denying that violation?
Admitting.
All right. I'll accept your admission as freely, voluntarily, knowingly given in 22 CF 2054 and 22 CF 2749. Adjudicate you guilty, reinstate the community control, extend it for 6 more months. Electronic monitor at $1 per day, reinstate all previous terms and conditions, waive cost of supervision, $100 court cost, $100 cost of prosecution, $50 PD application fee.
Yes, sir.
Anything I missed? Mr. Berry? Usually if you stand up, I miss something.
Are we reinstating, are we extending from February 24th, 2026 for 6 months?
For 6 more months.
Yes, sir, that's our extension.
And I apologize. Ms. Rivers said that to me when she came up. Maybe y'all didn't hear her. So.
And the first 6 months is going to be on community control.
Yes. All right. So, Mr. Webb, you're going to have to talk to probation before you leave. I'll need you to be fingerprinted, and then you have 30 days to appeal the judgment and sentence.
Yes, sir.
All right. Thank you, Mr. Webb.
Thank you. Thank you.
Yeah. William? Your Honor, this is Jeremy Williams before the court on 25 CF 702. We had hoped to try to resolve this today. We're not able to. My understanding is you have a court date in early June? Maybe.
1 second, Ms. Rivers. I did have a chance to go over my notes in the case, and I'm not agreeable to the trespass charge. I'll go forward on the burglary at this time.
Okay, we'll set it for depositions. If we could put it on the regular pretrial docket.
June 24th at 9 o'clock.
Yes, Your Honor, thank you.
All right.
Thank you, Mr. Williams.
Your Honor, I do have one out of custody.
Who's that?
Maddox Slusher.
Yeah, that was funny because I was thinking it was Slasher.
Your Honor, he's before the court on two cases, 25 CF 544, and I think the other one is 25 CF 545. The state had indicated in court yesterday, the offer was a PTI.
Yesterday.
Yes, yesterday, plea.
Oh, at plea day.
Yes.
Okay.
Oh, sorry,
so
yes,
then-
you weren't there.
I
Sorry.
had a fill-in judge yesterday, so Judge Ward would have been here.
She announced the offer of a PTI that he would that he would have the PTI on one case, and then the state would dismiss the other case. So my guess is the one case number would just remain in limbo.
No, I just dismissed that. I will dismiss that.
So it's not a plea to PTI?
No, just a
It's
PTI,
just a
and the
PTI.
state dismisses 25 CF 543.
Okay, so the PTI is 544. That's the smuggling contraband charge of a
Yes, sir.
controlled substance. So basically, it was possession of the controlled substance and then bringing it into the jail. All right, Mr. Slusher, do you understand this agreement? Did you go over it with Ms. Rivers?
Yes, sir.
Did you have any questions about it?
Yes, sir.
Okay, I just have to hear you out loud.
Yeah.
All right, Mr. Slusher, again, this is a pretrial intervention, which means it kind of diverts it from the court because there's not going to be a plea. I'm going to have you meet with probation as soon as he's available this morning to go over this with you. And you won't have to come back to court unless there's a violation. Understand? Anything else, Ms. Rivers? All right, let me have you give that back to Mr. Berry. Thank you. On Mr. Webb. Ms. Rivers, on Mr. Webb, just that he'll have to remain in until he gets the GPS, then he'll, okay.
He knows, Your Honor, I did tell him that.
All right, thank you. Thank you.
Yes, ma'am, that's fine.
Who do we have? Okay, Mr. Maddox.
Charles Russell, Public Defender's Office. Judge, this is Seth Krooks, present and approaching. Case numbers are 25 CF 696 and 697. These went in yesterday, and we're not sure why it got passed to today. So I think it was just a mistake. So we just want to leave it on the pretrial conference for June 24th.
What y'all do yesterday? Tell me, I can't get a feeling for arraignments again. I mean, it says 624. Can't see the minute sheet on that one. All right. So, Mr. Krooks, we're not quite sure why they passed you from yesterday. I know it was a different judge yesterday. He was just filling in for my arraignment docket yesterday. But they've already placed you on June 24th at 9 a.m. for your next pretrial conference. All right. Thank you, Mr. Krooks.
Schofield?
Charles Russell, Public Defender's Office. Judge, I'm covering for Mr. Maddox on these cases too. This is Robert Scoffield. Case numbers are 24 CF 1844, 24 CF 2080, 25 CF 398, and 25 CF 495. My understanding is that one of these cases was set for trial, but in preparation for trial, Mr. Maddox now has competency concerns, so we've filed for an evaluation.
I have a conflict.
We have filed for an evaluation, and so we're going to ask for a continuance to the next pretrial conference date.
Mr.
No
Schofield.
objection.
Your Honor, I was told to report something to you that happened at the jail by the officers, but if
You were told to report it by whom?
the Lieutenant Broxton, Oliver, and McNulty.
Okay.
I have some documents here, if I could please hand them over to you.
What are they, Mr. Russell?
It's captioned, Judge, a motion for discharge for lack of speedy trial. Is that it? And a written objection based on prosecutorial misconduct.
If you want to file something, you can do that by giving them to the clerk's office. They have to process them.
Your Honor, okay, by the officers, I texted up front and asked them to save the camera footage, but on the date of 4/29/25, Mr. Maddox came to see me up there at the jail. He came to me with an offer for 11/29, and I said, Mr. Maddox, I haven't even seen the footage. When I first had Miss Rivers, I only had her for a few weeks. She never brought the footage up there, and he kept saying that he's seen it, but I never seen it. And every time I would ask to see the footage, he said, look, that's not something I do. My investigator does that. And I said, well, if you've seen it, how come you can't bring it up here? He's like, look, are you going to take the deal or not? And I said, I want to see that footage. So he tells me, if you take the deal, I'll go get the footage. My office is 10 minutes up the road. So I lied to him because I wanted to see the footage so bad. I said, sure, I'll take the deal. Just go get the footage. He left the jail, and they put me back in ACR. When the officers came to take me back to my pod, I said, wait a minute, I got to wait for my attorney to get back. And they said, your attorney just left. And I said, he's just going up the road. He said, my office is 10 minutes up the road. Well, I timed him. He was only gone for 5 minutes. There's a big clock up there in ACR, and when he left, I looked at the clock the entire time, and he was only gone 5 minutes. That's how I know that he just went out there to his car and got the tapes. He had them the whole time, and he held them from me. So
All right.
Please, Mr. Maddox is not here to even respond to all those allegations, so I don't think it's appropriate for this defendant to make those statements at this time.
Well, the public defender's office is here.
But
And I was told that Mr. Maddox would be here via Zoom if there was an
And I can
issue
make
that needed to be brought up.
I can make those arrangements. I can contact him if the court wants to hear from Mr. Maddox.
All right, so Mr. Schofield, what we'll do is we're going to get Mr. Maddox via Zoom. We'll have him on the screen. It's my understanding he's out of town. But we'll have him up there like we talked about on Monday, and then you can bring your issues.
would you please take my documents, Your Honor, and put them in my file?
That's not how things are done. I don't handle they have to go and be processed.
I will send them to the clerk of court.
Okay, and I'm not trying to be difficult, Mr. Schofield.
No, you've been more than fair with me, Judge. Thank
Okay,
you.
well, I'm trying to be. We'll bring you back up once we get Mr. Maddox on the line.
Yes, sir.
All right.
Judge, this is going to be under my name.
Okay.
This is Dwayne Bonick, case number 24 CF 2696. And if I could have a moment, I believe we've reached an agreement. Okay. Put your initials just somewhere in here, in the margin. Dwayne James Bonick. Okay. So here's the whole signature. Judge, may I approach?
I just turned the Zoom on, so whenever Mr. Maddox is available. I'm not trying to rush you on that, Mr. Russell. I'm just telling you that I've turned it on, so I'll be able to see when he gets on.
Yes, sir.
All right, Mr. Bonick, can you raise your right hand? Do you swear or affirm that the testimony that you're about to give is the truth, the whole truth, and nothing but the truth?
Yes, sir.
All right. Can you state your full name and date of birth?
It's going to be Dwayne James Money Bonk. It's going to be 01/22/1999.
Say the last name again.
Bonk.
Bonk?
Bonk. B-O-N-C-K. But they spelled it wrong, but it's the same. It's Bonick. It's Bonk. B-O-N-C-K. Dwayne James Money Bonk.
Well, I understand, but I've got concerns that you're misspelling your own name.
I didn't misspell my last name, sir. No, I didn't.
Well, did they?
It looks like it, yes, sir. Yes, Judge.
Does he have his jail ID on him?
Oh, yes, sir, I do.
Pull that out and see what that one says.
as well.
But what I want to make sure is, if it's not supposed to have an I in it, that it does.
It's not supposed to have an I, sir.
It's spelled properly, because otherwise. So it's B-O-N-C-K?
Yes, sir.
We just have to make sure all the paperwork's
Oh,
correct.
I understand, sir. I understand, Judge.
Who's the state attorney on this case? Who's the only?
Mr. Sheik.
You all have a file that includes an NCIC on Mr. Bonk?
I can check it out.
I just want to make sure it's not a situation where I've got a score sheet that has 0 criminal history on it, but if it was, that's based on a misspelling of the name.
Even before checking, I can tell the court that we search also about date of birth and social security number. So it would give us, when we insert those data and the name is wrong, it returns like nothing found. So, but I can verify that. I can only say that as criminal history in Florida, it only has this pending case. That's for Florida. I can check out of state if there is any. I don't know.
Well, he's got a Louisiana driver's license, that's why I just want to make sure everything's accurate.
It appears he has the following from out of state. It shows some charges. Unfortunately, I cannot verify the outcome, like if it was the disposition of the cases. So if it was my case, I wouldn't include anything on his prior criminal history.
Okay. Because obviously, I don't have access to these types of things, so I just want to make sure that y'all have all the right information. So you're saying it's B-O-N-C-K?
Yes, Judge.
All right. Can we put that on the, all right. All right, so, and it's pronounced Bonk?
Yes, Judge.
Okay. Was there something you said after your middle name?
Dwayne James Money.
Money?
Yes, Judge. M-O-N-E-Y. I have 2 middle names.
Why is that not on the form?
Because the information is charged Dwayne James Bonick, so I always write my plea agreements with what's on the information, so it all kind of tracks.
All right, Mr. Bonk, you're here in 24 CF 2696. You're charged with aggravated assault with a deadly weapon, which is a third-degree felony, punishable up to 5 years in state prison. Do you understand that?
Yes, Judge.
And I've been given a plea and sentencing agreement that calls for you to plead no contest to that charge. You be adjudicated guilty, which makes you a convicted felon. Time served, pay court costs, which would be $867, $150 PD fee. All those would have to be paid within 90 days. Otherwise, they'll be sent to judgment. Is that the agreement that you wanted?
Yes, Judge.
Is that the state's agreement?
It is, Your Honor.
All right. And have y'all spoken with the victim in the case?
Mr. Sheik, it was his case, Judge. He indicated to me the other day that he had.
Okay. State have any reason to?
No,
I
Your Honor,
just be able to file.
No, I'm going through the notes, and he notated that he spoke with both victims, and they are okay with the plea.
All right. All right. So, Mr. Bonk, did you go over this agreement with your attorney?
Yes, Judge, I did.
Okay. And did you understand and sign it?
Yes, Judge.
And are you satisfied with your attorney's advice and representation?
Absolutely, Judge.
Are you currently under the influence of any alcohol, drugs, or controlled substances?
No, Judge.
Okay. Are you currently suffering from any mental health issues or concerns?
No, Judge.
Has anyone forced, pressured, or threatened you in any way to enter this plea?
No, Judge.
Has anyone promised you anything in return for your plea?
No, Judge.
You understand that by entering a plea of no contest, there won't be a trial of any kind, and you're giving up your trial rights, which are listed on page 2 of the agreement that you signed.
Yes, Judge.
And you understand you're waiving all potential defenses that you may have.
Yes, Judge.
Do you understand if you're not a U.S. citizen, this plea could lead to your deportation?
Yes, Judge.
All right, what is your plea to the aggravated assault?
No contest.
I'll accept your no contest plea as freely, voluntarily, knowingly given, adjudicate you guilty, sentence you to time served, pay court costs of $867 and $150 PD fee. That's to be paid within 90 days, or it'll be sent to judgment. And this is a guideline sentence according to the guidelines that I've been given that he does not score. All right, thank you, Mr. Bonk.
Thank you, Judge.
Be fingerprinted. You have 30 days to appeal. Thank you.
Charles Russell, Public Defender's Office. Judge, this is Daniel Endicott. It's my case. Case number is 25 CF 717, if I could have a moment. Stay in touch. Judge, on Mr. Endicott's case, he came in for felony plea day yesterday, passed to today to address the bond situation. Current bond is $1,000 cash professional. State is agreeing to change that to $1,000 signature, and then we'll set it on the pretrial conference. We'll need to move it to the pretrial conference June 23rd at 1.
He let me out.
Okay.
So state's agreement to $1,000 signature bond?
Yes, Your Honor, it is. We just have to determine the amount of restitution, and we couldn't, otherwise we would have had the plea agreement today.
All right, Mr. Endicott, based on the state's agreement, I'll give you the $1,000 signature bond.
Thank you, and all generosity, Ms. Phillips.
717.
Thank you, Judge. Sorry to talk above you. I didn't mean to talk.
Oh, it's okay.
And Judge, pretrial conference will be June 23rd at 1?
Because he's being released June 23rd at 1 o'clock.
Great. Thank you, Judge.
We'll see you back on that day, Mr. Endicott.
Yes,
Stay in
sir.
touch
I'll
with
make
your
sure.
lawyer.
Yeah.
for you.
I've got Mr. Maddox on the line. Before we get to Schofield. It'll take a second. Morning, Mr. Maddox. Can you hear me okay?
Yes, Your Honor, I can. Good morning.
Good morning. So we were handling Mr. Schofield's cases when he started talking about an event at the jail between you and him as far as a conversation about some videos. And we just thought we needed you to be in here to either listen to that or respond to that. So, all right.
Yes, Your Honor.
All right, Mr. Schofield, if you kind of want to take it from the beginning of your story about what happened with you and Mr. Maddox.
Yes, sir. I just wanted the court to know that on 4/29/25, Mr. Landon Maddox came to see me up at the jail, and he had an offer for 11/29 to resolve everything. And I said, why would I take that? I haven't even seen the video. He kept telling me how he's seen the video and how he knew it was me. And I was like, well, I haven't seen it. So I said, so he tells me that his office is 10 minutes down the road and he'll go down there and get the video footage if I take the deal. So I lied to him and said, I'll take the deal because I wanted to see the video footage so bad. So he leaves. They put me in ACR. The officers come in there to take me back. And I said, no, my lawyer's coming back in a minute. They said, well, where did he go? I said, he went to his office to get video footage. Well, I looked at the clock and timed it. He said his office was 10 minutes down the road. He wasn't even gone 5 minutes. He was gone less than 6 minutes, I know for sure. So he comes up there, shows me the video, and he says, all right, you're going to take the deal now? And I was like, no. So he become angry. And then he left. They put me back in ACR, and the officers come up there, and they said, man, why'd your lawyer just leave and come back like that? I said, he had to go get me some video footage. They said, did he bring you any drugs or narcotics? You're acting nervous, and he's acting funny too. And I said, no. They took me in there and strip searched me from head to toe, made sure I didn't have any drugs, and then they sent me back to, and I didn't even know he wasn't allowed to do that. So somebody...
Wait. He wasn't allowed to do what? You'll get your chance. You'll get your chance to respond in full, Mr. Maddox.
Thank you, Your Honor.
Only let me see the video footage if I promise to take the 11/29 deal.
Okay.
So somebody informed me. They said, "Man, I don't think he's supposed to do that." So I asked them to save the video footage up in ACR of that event, and I told one of the officers at the jail, and they said, "You need to tell the judge that."
Of what event?
Of them putting me in ACR, him leaving, and going and getting the video footage, and then coming back. Because he said he went all the way back to his office, Your Honor, but I timed him. He wasn't gone long enough to go all the way back to his office. That's how I know he told me something untruthful.
Okay. Mr. Maddox, do you want to respond to that?
Yes, Your Honor, I'll respond to that in full. Mr. Schofield's claims, quite frankly, this court are abhorrent, Your Honor. I went that day to show Mr. Schofield the videos. We went over both of the videos. He insisted on me going back to my office to get audio footage of a CD of the audio footage from whatever court date he wanted to listen to, the recording. I went back to my office, went there as quick as I could, told the jail I was doing that, came back, played the recording, told Mr. Schofield if he wants to take the offer, go for it. I said specifically, I am not coercing you into taking this offer, because he started making comments like that. He said, I understand, and the conversation ended at that point, Your Honor. Quite frankly, at this point, I don't know if my representation with Mr. Schofield can go forward making claims like this. He's putting my license in jeopardy, he's putting my career in jeopardy, and the claims are blatantly false to this court, Your Honor. I just, it's unbelievable.
Okay. Well, it sounds like, Mr. Schofield, your relationship with Mr. Maddox is not exactly conflict-free at this point.
It was the Circle K video, Your Honor.
Well, my issue at this point is I'm not sure, based on what I've heard today, that you want Mr. Maddox to be your lawyer anymore.
Yes, sir, Your Honor. Well, I just want to ask you if this matter could be investigated. Y'all look at the video.
I don't investigate. I'm not an investigator, Mr. Schofield.
There's no way he had time to go back to his office, sir. And I also think...
I'll happily respond to the bar in this matter, Mr. Schofield. I mean, go ahead and write your complaint.
All right. Based on this, obviously the relationship has gone adversarial. I'm going to allow for the Public Defender's Office to be relieved from this case and appoint the Regional Office of Conflict Counsel to represent you, Mr. Schofield. They're not here. No, it's the office.
Your Honor, I wouldn't lie on that man, and I'm not lying.
I understand that, but I'm not going to get into the middle of that. But if I had to make some determinations, I would do that, but we would have a full-on hearing.
I mean, I'm in trouble with you. You think I would lie on him?
Can I finish, Mr. Schofield?
Yes, sir, I'm sorry.
once a relationship goes this sour between a lawyer, an appointed lawyer, whether it's the PD's office, the RCC office, or a private lawyer who's been appointed in your case, I can't let that go forward. Obviously, you don't want Mr. Maddox to represent you. You think he's lying to you, and he says you're lying about this now. So I don't see any other option at this point other than to get you a new lawyer.
Okay.
All right. And it'll be the Regional Office of Conflict Counsel, so it'll be Scott Klein's.
And Your Honor, I sincerely apologize for my demeanor, but
I understand, Mr.
I don't know
Maddox.
how else to respond.
I understand. Obviously, it seems to be a heated situation, and I'm not going to really entertain more about it because I think I've resolved the issue as need be. Obviously, if there's something else y'all want to look into, I mean, that's not for the court to be involved in.
Okay, thank you.
All right, so I'm going to continue your case to June 24th at 9 a.m. I'm sure Mr. Kleins will come out to see you as soon as he knows about the appointment. I'm not sure how quickly that will get to him, but if Mr. Russell, if you could help us out by sending over an order that relieves the public defender and appoints RCC.
I can do that, Judge.
Thank you, Your Honor.
All right, thank you, Mr. Schofield. Thank you, Mr. Maddox.
Yes, Your Honor, thank you very much for allowing me to appear via Zoom for this matter.
All right, I appreciate it. Thank you.
All right.
I had one last case, Cameron Thomas, that's a Mr. Maddox case, 23 CF 1517. Cameron Thomas?
Cameron Thomas?
Page 5 on my docket, Judge.
I've got it as a PTI recall.
Correct, Judge, and it was my understanding it was going to be a PTI with a plea, but no response from the gallery, Judge.
It was supposed to be a PTI. The clerk's didn't say.
Right.
If I'm not mistaken, he was in court here.
He was here on Monday.
Yes, Your Honor.
I wonder if there was some confusion. I wish I had Mr. Maddox back.
Sorry about that, Judge. I didn't even think about that.
Could I, Your Honor, request a KPSA with
I was gonna-
$2,000 cash or profit, with that bond, so that, unless the court obviously doesn't.
No, I was inclined to do the same thing, except I was thinking more of a signature bond. Just because he was here, he was supposed to have PTI. His lawyer is, you're filling in, Mr. Russell. I'd hate to find out that there was just some issue of miscommunication and then have him arrested and have to post $2,000 cash or professional to come in and tell us that there was a miscommunication. So I'm going to do the KPS with a $1,000 signature bond. Obviously, if y'all talk to him, Mr. Russell, and turns out there was an issue there, just file something and we'll address it.
Yes, sir.
We'll set it for a hearing, Judge.
This is already on a diversion. All right. I'm sorry for the delay, Mr. Henderson. I just want to make sure I've got all my paperwork in line.
Absolutely, Judge. I apologize.
Do we have a score sheet for this? All right. So score sheet shows 77 months, so this would be a downward departure, but, all right, based on an uncoerced plea agreement.
Yes, sure.
All right, Mr. Miles, I'm not sure where we were in this, so I'm going to kind of start from the top. So can you raise your right hand? Do you swear or affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Yes.
Okay. Have you gone over this plea and sentencing agreement in 2019 CF 3289?
Yes.
With your lawyer?
Yes.
Did you understand and sign it?
Yes.
It calls for you to have 5 years Department of Corrections credit for time served, and that's to run concurrent with your other 2 cases?
Yes.
Okay. Is that what you want to do today?
Yes.
Are you satisfied with your lawyer's advice and representation?
Yes.
Are you currently under the influence of any alcohol, drugs, or controlled substances?
No.
Are you currently suffering from any mental health issues?
No.
You understand, or I'm sorry, has anyone forced, pressured, or threatened you in any way to enter this plea?
No.
Has anyone promised you anything in return for your plea?
No.
You understand by entering a plea there won't be a trial of any kind, and you're giving up your trial rights, which are listed on page 1 of your agreement.
Yes.
Do you understand you're waiving any potential defenses that you may have?
Yes.
Do you understand if you're not a U.S. citizen, you could be deported due to this?
Yes.
What are the court costs going to be on that? All right, Mr. Miles, what is your plea to the harassing a witness first-degree felony charge?
No contest.
All right, I'll accept your no contest plea based on the plea and sentencing agreement. Adjudication of guilty, 5 years Department of Corrections with credit for time served. That's to be concurrent with 17 CF 3441 and 20 CF 1370. Be $515 in court costs. Mr. Miles, I'll give you 90 days from the time you're released to pay those court costs. Otherwise, it'll go to judgment.
All right.
Okay. Anything that I've missed? This is, again, a downward departure based on state's uncoerced plea bargain.
That's the only thing I would add is that I reviewed the score sheet with my client, and we have no objection.
Oh, no objections. Thank you, Mr. Henderson. All right. You need to be fingerprinted for this, Mr. Miles. You have 30 days to appeal the judgment and sentence.
Thank you, Judge. That's all I have.
Thank you, Mr. Henderson.
Good to see you.
Good to see you.
Yes. Brown's fine. Morning, Your Honor. Judge, this is Chad Brown. We thought we had a deal. We had offered at one point 10 years as a mandatory minimum, followed by lifetime probation. State talked with the victim, and turns out they can't go along with that. We've since gone back and forth a couple of times, but we don't have an agreement at this point.
You said 10 years minimum mandatory, or is that just a score?
That's minimum mandatory. He's facing is at 10-20 life. He's charged under 10-20 life.
Okay. All right. So what do you want to do today, Mr. Williams?
Judge, I guess we're just going to have to put it on the next docket. We'll continue to work on it. But at this point, I've inquired of the state if they would meet me halfway. I think they need to speak with the victim again before they can make any representations along those lines.
All right. Well, this case is from September of 23, and he's been continuously in custody.
Yes, sir.
Jail since then. So let's get a resolution next time around, or it's just, we're going to set it for trial.
Yes, sir.
We'll be ready for trial.
Okay. So I'm going to call this last continuance.
Yes, Your Honor.
Thank you, Judge.
All right. We'll see you back on June 24th at 9 o'clock, Mr. Brown.
I'll come out and see you again, Mr. Brown. Judge, this is Jared Fountain. This is a negotiated plea.
What's the plea? It's charged?
Yes, as charged.
Just-
It's two felony cases.
Yes, sir.
So what is the Chrome program?
It's a
I just haven't heard of it.
Yeah, it's a new one to me as well, Judge. In fact, I had gone out to see someone else, and he was being interviewed for that program, and I ran into him. They emailed me right afterwards that they were going to take him. It is an inpatient program.
Okay. How long does it usually take?
Judge, I want to say the email that they sent me, they were indicating that the minimum was a 7-month program. 99,
9 and 9.
I'm sorry.
You can go there for 9, stay
Okay.
You can be there for 18 months.
All right, he's informing me that it's, could be as long as 18 months.
Where's that at? Mariana? All right, Mr. Fountain, can you raise your right hand? Do you swear or affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth? Can you state your full name and date of birth, please? Okay, you can put your hand down, Mr. Fountain. All right, Mr. Fountain, you're here in 24 CF 2726 and 24 CF 2780. In the former case, it's battery on a law enforcement officer, which is a third-degree felony punished by up to 5 years in state prison. 2 counts of a violation of domestic violence injunction, which is a first-degree misdemeanor punished by up to a year in county jail. And then in the other case, it's possession of a firearm, weapon, or ammunition by a convicted felon, which is also a third-degree felony punished by up to 5 years in state prison. Is this a constructive possession then? Okay. So state's stipulating that it's constructive possession for purposes of there not being a minimum mandatory.
Correct, yeah.
Okay. And it looks like Mr. Fountain also scores on his guidelines, so what's the reason for the downward departure?
The need for treatment and the plea
Unenforced
bargain.
plea bargain?
Yes.
Is that accurate, Mr. Williams?
Yes, sir.
All right. All right, Mr. Fountain, did you go over this plea and sentencing agreement with Mr. Williams, your attorney? Did you understand it? Did you sign it? Is this what you want to do today? Are you satisfied with Mr. Williams' advice and representation? Are you under the influence of any alcohol, drugs, or controlled substances? Are you currently suffering from any mental health issues? Has anyone forced, pressured, or threatened you in any way to enter this plea? All right, and let me just announce it again real quick. So we talked a little bit about it, but I didn't give you the whole term, so I want to make sure you understand what you'd be pleading to. The plea and sentencing agreement with the state calls for you to be adjudicated guilty as charged as to all 4 counts. It'd be the Chrome program, which is, it'll be bars to bed, which means you don't leave the jail until there's a bed available for you. Followed by 2 years of probation with ECLC or similar. ECLC is Emerald Coast Life Center. You know that, right, that Mr. Fountain? $897 in costs in 1716 case. $515 costs in the 2780 case, plus a total of $250 in PD fees. Is that what your understanding of the plea agreement is? All right. Has anyone promised you anything other than what I just read in order to get you to plea? All right. Do you understand by entering a plea to both of these cases there won't be a trial of any kind? Do you understand you're giving up your trial rights, which start on page 1 and continue to page 2 of your agreement? You understand you're waiving all potential defenses that you may have? You understand this calls for an adjudication of guilt, so if you're not previously, you'll be a convicted felon because of this. I understand you're charged with possession by a convicted felon, but I want to make sure I still say that. All right, and you understand that if you're not a U.S. citizen, this plea could lead to your deportation. And what is your plea as charged? Battery on law enforcement officer, 2 counts, violation of domestic violence injunction, and possession of a weapon by a convicted felon. I'll accept your no contest plea as freely, voluntarily, knowingly given based on the plea agreement. The adjudication of guilt, go to the Chrome program, again, bars to bed for that, followed by 2 years of probation once you're released. You'll have to do ECLC or similar. In the 1716 case, it's going to be $897 in costs. In the 2780 case, it'll be $515 in costs, and a total of $250 for PD fees. That's $100 per case and $50 for the application. All right. I know you're. Oh, what did I miss?
Time served on misdemeanor.
Or you want to do the
That's
misdemeanors?
how we normally do it, Judge, so that would be acceptable to us.
Fine.
All right.
Also,
So.
the case number is 20.
Oh. It's right up in the style of the case, but it's not on the other. So it's 27, 26. So you got 2 1s instead of 2 2s. All right, so that'll be 24 CF 2726, not 1716. All right, so it'll be time served as to the domestic violence injunction violations. Mr. Fountain, you're going to be on probation once you're released from your program, so you're going to have to talk to them before you leave. I need you to be fingerprinted, and then you have 30 days to appeal the judgment and sentence of the court. Again, this is a downward departure based on need for treatment as well as uncoerced plea bargain. All right, thank you, Mr. Fountain.
Thank you. Thank you, Judge.
Supervision fees be waived.
Yes.
If the order says complete the Chrome program, we don't have any jurisdiction over him right now. So if he doesn't do the Chrome program, that would mean someone else would have to bring him back to court because he's not on probation.
Which is the problem that we ran into yesterday. Normally, the way that I'm used to doing it, it's X amount of program with a time or X amount of probation with a special condition. But
That's the intent, like yesterday we modified
Well,
it.
it says followed by 2 years probation. It doesn't say 2 years probation with special condition. So we're going to have to change that.
Well, Judge, they got us writing it up, and I'm writing it up based on what the state tells me.
Let's not just figure out who got it wrong. Let's figure out how we can get it right.
What I would suggest is, since it's as much as an 18-month program, make it,
Mr. Fountain, come back up to the podium, please.
make it 3.5 years. No, yeah. So that'd be what, 40 months?
Make it even easier, do 4 years, and then upon successful completion of the Chrome program, 1 year on, and then early terminate after 1 year, basically. That's what I want to say.
All right.
What it does, it just gives them jurisdiction over you.
Do you understand that? So, Mr. Fountain, I'm going to change what your sentence is going to be based on what we've talked here. It's going to be, you tell me if you have any objections or disagreements with what was just said, but I want to make sure you spell it out because thankfully to Mr. Berry, he explained how he needs to have it differently for purposes of probation, that it's going to be 4 years probation. And then upon release, May early term after 1 year. And that the Chrome program will be a condition of your probation. Mr. Williams, I'm going to have your initial next to the Chrome, but I want to initial again here.
That was my client's initial.
Yeah, I know. I just, so it doesn't look like he's initialing to everything else that I just wrote down here. And I want him to initial a second time that he's seen how I've changed this. Chrome is a condition of probation. There you go.
All right, let me get your, I'm going to say initial right there.
Again, it'll be time served on the 2 misdemeanor cases. Counts. All right. Any questions or concerns about that, Mr. Fountain? All right. And you've initialed there next to where I've written the new things in. All right. Thank you, Mr. Fountain. Same thing. Talk to Mr. Berry. Hopefully he doesn't find any more mistakes that we've made. Or hopefully he does, actually, if we didn't made any other mistakes.
Supervision fees waived based on the public defender.
I thought I said that earlier, but if I haven't, supervision.
Solo over here, yeah.
Cost of supervision would be waived due to the fact that he's indigent.
And it is a bars to bed.
Bars to bed. I
It
did
is
say
bars to
that.
bed.
What else do we have? Who has Mr. McDonald for the state? I think it's usually Mr. Sheik, right? He was an add-on. All right.
Your Honor, I believe the court decided to set this case for today because Mr. McDonald filed this demand for speedy trial.
Okay. So, Mr. McDonald, you're here in 24 CF 2917. We were just here on Monday where we talked about what kind of hearings you wanted to have set.
Yes.
You wanted to have some depositions set. And then yesterday or 2 days ago, I received a copy of your motion for speedy trial upon demand under 3.191B, which is basically saying I want my trial within 60 days.
I don't think that was supposed to have been filed under 2917, Your Honor.
It was filed on.
That's the number that's on it.
That's the number that's on there? Well,
Because here's the thing, and I want to make sure this is clear, Mr. McDonald. Do you have a copy of 3.911?
I have a copy.
Because I want to make sure you understand something. I'm not giving you advice on anything. I'm just making sure you understand that when you make a demand for a speedy trial, you're saying, I'm ready for trial within 5 days, and I've investigated my case, and I'm ready to go. And you filed it in a case where 4 days ago, you said you needed to do depositions.
I put the wrong case number on there, Your Honor. I meant to put the case number for 713, the new one, the 2025 713 case. I apologize to the court for that. It was a mistake.
Let me just tell you, so this is, when you go back and look at it, 3.191, and I'm not scolding you or anything, I'm just trying to make sure you understand this, you're not represented by counsel. Let me ask you, I have to ask you every time you're here. Do you want me to appoint you new counsel, Mr. McDonald?
No, sir.
Okay. And you understand the advantages of having counsel?
Yes, sir, I do.
The disadvantages of not having counsel?
Yes, sir.
Okay. 3.191G, demand for speedy trial, and the accused is bound. That means you're in custody.
Yes.
A demand for speedy trial binds the accused and the state. No demand for speedy trial shall be filed or served unless the accused has a bona fide desire to obtain a trial sooner than otherwise might be provided. A demand for speedy trial shall be considered a pleading that the accused is available for trial, has diligently investigated the case, and is prepared or will be prepared for trial within 5 days. A demand filed by an accused who has not diligently investigated the case or who is not timely prepared for trial shall be stricken as invalid on the motion of the prosecuting attorney.
Yes, sir.
All right, so what you're telling me is you intended to file it in a different case.
Yes, sir, I did.
In which case did you intend to file it?
2025 CF 000713.
713? Let me pull that up. I mean, you're still going to have to file it. I can't just transfer it over. I mean, I'm basing this on the number that you put on it.
I made a mistake, Your Honor. I'm sorry.
Okay. So I'm looking at that case, and you haven't even asked for discovery. Is that right?
No.
So you don't want to participate in discovery in that case?
No, I'm ready for it. I've been studying this case since they brought it to me. It's over a year old.
Well, it's a 25 case.
It was originally filed in 2024, May 5th, May 6th of 2024.
Well, that may be when it happened, but the
Yes.
case isn't that old. All right, so, I mean, that case is only from April of 2025.
I understand that, Your Honor, but this case has been ongoing, and I was investigated in October with a vehicle swab.
All right, an investigation may have been going on for some time.
Right.
But as far as speedy trial, that's based on when you're arrested.
Yes, sir.
So that date is only early April of 2025.
Yes, sir.
Speedy trial in this case is supposed to expire on 9/29/25.
I understand.
Let him know.
But you can file your motion and I'll act accordingly. I was prepared to go forward and deal with it for the other case, but you're telling me that's wrong. So just to make sure, are you withdrawing your demand for speedy trial in 24 CF 2917?
No, sir, I filed for wait a minute, I'm correction, Your Honor. I didn't follow the demand for speedy trial in that. I filed a motion to dismiss in that case, but not a demand for speedy trial. I improperly put the wrong case number in the demand for speedy trial, 2917, but it was meant for 000713.
I understand, but the new motion for speedy trial upon demand that was filed based on your case number that you hand wrote on there, 24 CF 2917, are you withdrawing that motion?
Yes, I'm going to withdraw that from that case.
From
Yes.
that, from 2917?
Yes, sir, I understand.
Okay, I'm not trying to be difficult, Mr. McDonald, it's just I have to do certain things if there's a demand for speedy trial.
Yes, I had to withdraw that because
And
it
then
was
once you
improper.
file it in the other case, we'll deal with it accordingly. But you just have to understand that when you file a demand like that, we have to have a hearing within 5 days. So I just want to make sure I'm
Yes,
setting
ma'am.
them quickly when you ask for those things.
Yes, sir, I'm sorry.
Again, I just want to make sure you, I understand what your intent was.
Yes, sir.
So that's why I'm asking the questions. All right, so his motion for speedy trial upon demand in 24 CF 2917 is withdrawn.
Is withdrawn, yes, sir.
And then we'll address the other one once I see it.
Yes, sir.
All right.
All right, thank you.
You know, just for the record, though, I would like to state that, make sure that he understands that case that he wants to file a demand for speedy trial has DNA evidence and also GPS evidence. He's not going to be entitled to obviously see it because he's saying he's ready to go forward.
And he hasn't filed a demand for discovery, which I asked him. So you understand you're not going to see any of the evidence that
I
involves
understand that,
GPS.
but the evidence is circumstantial, Your Honor.
Okay. But you're
And
not
there's
going to
no
be able to see it in
witnesses.
advance. Do you
There's
understand
no
that?
witnesses.
Say again?
There's no witnesses in that case, Your Honor, and the evidence is circumstantial and it prejudiced the defendant because it violates the rules of discovery.
You haven't asked for discovery.
I understand that, Your Honor.
And I hate to say this because I want to make sure everyone understands it, so listen to everything I say. Evidence that the state brings against you is intended to be prejudicial. It's whether or not it's overtly prejudicial. The evidence is supposed to be showing that you've done something wrong.
Well, it is overly prejudicial.
Okay, well then file your 403
Prejudicial, I
motion.
mean.
Mr. McDonald, again, I'm not trying to suggest anything, but you've confused a lot of different concepts and motions over these cases, and I'm starting to get a concern that you are not able to handle these cases on your own. Would you like me to appoint you an attorney or
No, sir, I do
standby
not.
counsel?
No, sir. I feel like now I'm being coerced out of my right to self-representation.
I'm not, Mr. McDonald. I just want to make sure you understand that.
I understand that.
You're saying something violates the discovery rules when you just admitted that you haven't even asked for discovery.
I have not asked for discovery, Your Honor, but the thing about it is that this case right here, this 713 case, is where I used to live at a residence.
I wouldn't talk about the facts of your case, Mr. McDonald.
Sir?
I wouldn't talk about the facts of your case.
Yes, sir.
I just don't want you to do something that's detrimental to it by admitting something here in open court.
Yes, sir. May I be excused, Your Honor?
Do you want to say anything else as to why you think I'm coercing you into get counsel?
No, sir, I do not. I just feel like I came here and being embarrassed in front of the public, and like I'm stupid. I'm not stupid.
How am I embarrassing you, sir?
I'm not stupid.
You filed something with the court.
I understand that, Your Honor, and I made a mistake at putting the wrong case number on there. I have a lot going on.
Well, I understand that. I just want to make sure that we're being clear on things. I'm
Yes,
not
sir.
trying to embarrass you in any way. I'm simply trying to make sure I understand what you're asking the court to do. And so I understand you're
I'm going to refile for the demand for speedy trial in that case.
Okay, and I'll deal with it once it's filed.
Yes, sir.
You're excused, Mr. McDonald.
Yes, sir. Thank you.
I apologize if you think I've done anything to embarrass you.
Morning, Judge. Judge, this is K.O. Gary. Mr. Gary's set this morning, I believe, for a bond motion. This is the case where he recently got out of Florida State Hospital. I'd inquired about a possible time served plea. At this point, he's got a year, 206 days in. The original offer in the case was 24 months state prison. So if there's not... The original offer was 24 months. That would have been a downward departure, Judge. His lowest permissible is 56.475. in any event, I'm prepared for a bond hearing and filed a motion for him if that's what we need to do.
I apologize, the motion wasn't in the system, so I'm looking up in benchmark right now.
I'm sorry, Judge.
It just takes a while for it to be processed, so I'm just reading it now. I've reviewed your motion. Mr. Williams, go ahead. Do you want to present any evidence, or is it just argument?
Judge, just argument. Judge, he's well stabilized on medications. When all this happened, he was not. He is diagnosed as a schizophrenic. I've met with him. He's been in court. The medications are working, and he understands that he's got to take those medications. And if he starts feeling or thinking to himself, you know, I'm doing really well, maybe I don't need them after all, that he's doing really well because he's on his medications, and he understands that. He's got a mother that lives here locally that he would be living with. Her name is in the motion, and the location's in the motion. We're just asking that he be sent home. I may have some further evaluation work from the local forensic psychologist while we're waiting for his case to come up again, but I do think ultimately this is going to be resolved.
1 second.
Now, my one concern is I've got some, at best, anecdotal information. There may be some other jurisdictions with warrants. And in an email I'd sent to the state, I pointed out that if we did resolve it with a plea, that if there are any warrants, they could serve them on him and get him taken care of. Obviously, it's not my intention he'd be removed from the jurisdiction of the court.
Do you think has warrants from Florida?
Judge, let me see where I got that from. I think that there was a note in one of the court documents, probably a first appearance document or something along those lines about, or maybe it was the mental health summary from Pretrial Mental Health Services. But I don't actually have any solid information on that, Judge. You would have better access to that than I do. I'm sorry. Okay. He doesn't believe he has other warrants, Judge. And the pretrial services stuff is from 23, so.
Your Honor, I object to reinstating the bond. He was out on bond on 23 CF 2006, and the underlying offenses in that case was domestic battery by strangulation and felony battery. The prior record of this defendant includes driving without a valid license, unlawful sexual activity with certain minors, which makes him a sex offender, sell, manufacture, deliver controlled substance, 2 of those in the prior records, and then DUI and assault. He's currently charged in 23 CF 2006 with failure to register as sex offender. He scores a minimum presumptive prison sentence of 26 months, .475. Indeed, the state did offer a downward departure of 24 months. However, he scores more than twice as much. as I mentioned, he's a sex offender, and he violated one of the requirements of the sex offender statute by not registering his address. I also was on probation, on violation status, is not automatically entitled to a bond. So for those reasons, the state requests that defendant's bond motion be denied.
Judge, if I can follow up, if you look at the confidential mental health report from September 6, 2023, defendant reports symptoms of psychosis to include auditory visual hallucinations and delusional type thoughts. Presents with active hallucinations, with threats of violence, delusional thoughts, refusal of treatment. Judge, he was...
For a second, Mr. Williams?
Yes, sir.
If you want to point out for me to read the report, I can do it. But if you want to, I mean, you're reading a confidential mental health report out loud.
Yes, sir. Then I'll ask the court to review the report. I believe you also have the psychologist's original report from where he was determined to be not competent. The point that I'm trying to make is at the time that these events occurred, he was severely delusional, was off his meds, and he's currently stabilized on meds. He doesn't represent the same risk that he did back in 2023. I don't normally make a practice of estimating gain time, but at this point on the 24 months, I think what he'd actually serve would be a little over 20, and at this point, he's got a little over 18 in.
Would he get gain time on his entire sentence if, based on what he did?
Judge, I don't know. I did calculate it as 18.
The plea agreement that we always use talks about how no one's making any sort of comment on how much time he'll actually serve because of things like gain time. So even if you told him that, I would tell him he really can't rely on those things.
And I don't. That was not for his benefit.
Well, but I have to make sure it's clear that it wasn't for him.
And for the courts, in terms of the likelihood that he'd have an incentive to flee the jurisdiction or something of that nature. He simply doesn't really have that likelihood. Also note that originally the recommendation was a cash professional bond. But they scratched through and put no bond. Now, that may have been because of the subsequent offense.
He's violated his probation, according to the allegation, by committing another felony.
Yes, sir.
So, I mean...
I believe the other felony, though, was the failure to register, which, again, if he's delusional, it's going to be hard for him to comply with those requirements.
I'm just going through the
Yes, sir.
previous Dr. Zeman report.
Judge, there's also similar notations in his first, one of his reports from Florida State Hospital in terms of the delusional nature of his belief system at the time. It looks like that would be.
Evaluated for insanity at the time of this offense, right?
We requested it, Judge, but Dr. Zeman felt that he couldn't do proper evaluation at that time because he was incompetent. So if we can't get it resolved, I'll have that done.
That's part of my concern is,
yes, sir.
No offense to you, Mr. Williams, but you saying that he didn't know what was going on at the time is not the same as, Dr. Zeman or Dr. McDonald or whoever.
Oh, yes, sir.
Telling me that's the case. And, my concern is the allegations of the case are that he was on probation for domestic violence by strangulation, and he was found to be living with the victim for which he had a no contact order.
Yes.
And then that also includes the failure to register because he's living in a place he's not supposed to be living according to his sex offender registration.
Yes, sir. I'm sorry, Judge. I thought you.
But anything else you want to say, Mr. Williams?
I was just going to, if the court will look at the notice of confidential information, the report that's attached to that, the one filed on April 2nd.
I'm looking at it.
Get to the page number, just 1 second. Judge, observations, page 3, paragraph entitled Observations Upon Admission and During Treatment.
I've reviewed this before because my version is highlighted. That means I've looked at it and highlighted
Yes, sir.
it in the past.
That's.
So I've read it. Obviously, it's concerning, but does that rise to the level of he should be released on a violation of probation and a new law violation? When that normally wouldn't happen, short of a doctor saying at the time that he couldn't have, that he was NGRI, basically.
Yes, sir. Well, if we get.
There's a report to that effect.
Not yet, Judge.
I think you could reconsider, the court would reconsider, but as of now, I'm going to deny the motion to set the bond.
All right, Judge.
I've got concerns with his history. Obviously, he's required to register. There's a violent felony for which he's on probation. I know it doesn't necessarily fit into any of the categories, but I've got some concerns about his history, his substance history, and whether or not that would stay stable if he were to be released at this point until I see something from one of the doctors saying he couldn't have complied with the law because of his mental health at the time that these violations were allegedly done.
Yes, sir.
But I'll reconsider if there's new information specifically that.
I'll go ahead and have that done, Judge. We've already got it worked up.
Okay. And if there's a report that comes back and says something like that, bring it back as quickly as you can, Mr. Williams.
I will, Judge.
And the state will consider that as well, of course.
All right, so Mr. Gary, the judge is not going to let you out on bond, all right? But I'm going to have Dr. Zeman come out and do that next report to determine whether you're competent at the time, okay? Or legally sane at the time.
Thank you.
Thank you, Judge.
Anyone else? All right, then we'll be adjourned.